Welkom op het webinar Intellectueel eigendom en artificiële intelligentie. Het webinar zal plaatsvinden in het Engels. Elie is een Engelstalige spreker en hij zal straks het woord overnemen. Ik ga heel kort de introductie doen. Dus heel kort Vlaio voorstellen voor degenen die het nog niet kennen. Vlaio is het agentschap Innoveren en Ondernemen van de Vlaamse overheid. De missie en opdracht van Vlaio is eigenlijk rechtstreeks informatie en inspiratie gaan verlenen aan ondernemers over allerlei thema's en ook antwoorden op korte vragen via telefoon of mail via ons contactcenter. Over verschillende thema's, over subsidies, events en opleidingen. En ook concreet aan ondernemer met ambitie en plan naar groei en innovatie of transformatie gaan bijstaan via coaching, advies en begeleiding op maat door een bedrijfsadviseur van Team Bedrijfstrajecten. Onderstreeks hebben we ook een heel netwerk aan partners waar daar eventueel zal doorverwezen worden en waar ook allerlei initiatieven richting ondernemers gefinancierd worden. Algemene info vindt u op vlaio.be via onze nieuwsbrief en zeker via ons LinkedIn-kanaal. Dus de links die hier staan en slides we later nog krijgen. Nu puur rond intellectueel eigendom, waar over deze sessie ook gaat, hebben we ook informatie, eerste lijnsadvies en begeleiding. Dat kan ook via ip@vlaio.be. Geven we ook informatie over financiële ondersteuning, zowel subsidies als fiscale maatregelen. En binnen innovatiedossiers is een begeleiding mogelijk. Als we dan kijken naar gaming, media en evenementen of audiovisuele sector, dan staan de contactgegevens van Chris en Bruno, onze collega's, hier ook bij. En dan hebben we ook verschillende tools rond intellectueel eigendom, waaronder bijvoorbeeld de ID-scan. Een ID-scan is een soort vragenlijst die je kan gaan invullen. En op basis van de antwoorden krijg je eigenlijk een gepersonaliseerd document met de relevante intellectueel eigendomsrechten voor jouw specifieke case. Create Protect Benefit is een platform gemaakt voor ondernemers waar intellectueel eigendom eigenlijk op de hankelijke manier wordt uitgelegd en dat je ook heel hard kan zien als ondernemer wat er relevant is voor jou en ondernemersverhalen terugvindt. En we hebben ook verschillende publicaties op onze site. En heel concreet organiseren wij ook infosessies zoals deze en contactdagen. Op de contactdagen intellectueel eigendom kan je eigenlijk met een concrete case advies gaan vragen aan een onafhankelijke expert dat is gratis advies. En dat kan dan gaan rond een expert bij octrooien, rond merken, rond auteursrecht of in de design- en modesector kan je ook vragen gaan stellen. Op 28 mei, op een donderdag, is eigenlijk onze volgende contactdag. En die is dan ook meer gericht op gaming, media en evenementensector of audiovisuele sector. Dus voor degenen die vandaag aanwezig zijn, bij een concrete case kan je altijd een gratis gesprek aanvragen. Dan is ook nog een link van de IP Helpdesk, waar je ook concrete IE-vragen kan gaan stellen. Voilà, so I will let Elie take over for me.
Thank you, Jan. All right. Pleasure to see you all today. I'll have the pleasure of introducing you to IP and AI in the creative sector. My name is Elie. I'm an associate researcher at the CITIP, so a Center for IT and IP Law at the KU Leuven University. Josephine van Erpe is an assistant professor, and she helped me a lot on the slides. I've specialized after my legal studies on the fields of IP. In more particular on the subject of artists' rights and copyright. And now I work on an IP-related project called iGame. It's a new funded project. So we try to create a platform that would be both transparent, ethical, and cheaper to maintain and to create video games for the cultural sector. Our goal is to have the fashion industry, cultural industries, meaning museums and inclusion professionals, working together to create a platform that could attract many parties into co-creation processes. And my job on that is to make sure that the IP-related aspects are sound and that we have opportunities for research on that field. The field of co-creation is, of course, very diverse. You've heard, I guess most of you, a good presentation just earlier about it, and we are trying to find new ways, basically, to make co-creation happen in a more open process, basically. I've heard that there's a lot of gaming professionals in this call as well, industry professionals, and it would be great also to just have your feedback on such a project. So if you're ever interested in wanting to know more about the project, the link will be in this slide. You can get in touch with us. We are always looking for feedbacks, questions, opinions, whatever. And now, yeah, I've got the pleasure of truly starting this webinar on a very interesting topic, IP and AI. The first thing to do then is to discuss IP very broadly. What is IP? I'll take the example of video games several times. As you can understand, this is a topic that I specialize in a way now. And it is quite representative of what IP can be in creative industries. There are many layers to IP. So the protection of intellectual property can take many forms, can take many shapes, from copyright, which is the easiest one to get. There's no formalities, just the creation, the process of creation and expressing something on the paper in a way grants you a protection. But then there's the trademark that is often used, design rights, patents, trade secrets. It's a very broad category of rights that protects any creation. The example I've given you here on the right is the example of a Nintendo. When you are trying to search for a Nintendo related trademarks or patents, you see dozens of them. You see how broad they can be and how thoroughly this product, for instance, is protected by Nintendo, even though the product is not sold anymore. You see the impact of trademark there. It can be very long over time. It can cover a broad range of countries. So this is the first advice I can already give you. I will try throughout the presentation to give you as many advices as well as information regarding the legal sphere surrounding IP and AI. It's to always have a background check done when you are creating something. In any creative industry, this is the first and most important step. I've had the pleasure of attending a game conference a few months back, and it was, from a legal scholar perspective, quite astonishing how low the level of protection was for many companies. Trademark as many things as you think are relevant. It could be the name, it could be, of course, the name of your company, it could be the logo of the game. It can be very broad. And this is the first advice to avoid any problems on the long run. Also AI related. Having formal protection thanks to formalities linked IP rights is fundamental. Now that we know a bit what IP is, of course, AI, it's ubiquitous. You don't really need a definition, I guess, of AI. However, we can just consider it as overall data-driven algorithmic models. It's almost entirely, or I mean, very often based on machine learning. So it makes relationships, statistical relationships between data sets and information. So it's fed on a lot of data to make predictions. So a very essential first information about AI and IP is that because of this, the very nature of AI, it by definition, for the time being, cannot create something new. Creation is in a way inherently human until now, because what it only does is a sort of aggregation, a mix of information it has found elsewhere. Of course, I've given you different examples here of tools that are AI based and that can be used in the creative sector, whether it be for audio, video, of course, LLMs, text writing, image generation. I mean, it's extremely broad. There's the inclusion now of vibe coding as well, which is has been emerging over the last few years, I mean months, in the commercial sphere at least. And that also will definitely be a game changer and pose a lot of questions from an IP perspective. And on this slide as well, I've taken the liberty of adding a few of the frameworks that are framing AI at the moment, legal frameworks that are framing the AI environment within the EU. Of course, the AI Act is the big one. Everybody has talked about it, and it will be talked about for years and years. And the main problem I have for individuals that would want to try to understand it the best they can is the timeline of its entry into force, which is very confusing, which is why you will find here a link to a website, which is quite well done, that gives you an exact timeline of when each provision starts to apply, enters into force in the EU. Of course, many concerns are related to cybersecurity and privacy. So the GDPR and NIS2 directive are extremely related to the topic. The analysis of the protection of privacy within the AI sphere is of paramount importance at the moment in scholars' spheres. And there's a lot of transparency issues that the AI Act tries to mitigate, and that the DSA Act, Digital Service Act, also tries to compensate for and mitigate. So, very broad overview, of course. The structure of the presentation will be divided to try and cover as many topics as possible. The first section will be very brief. I won't go into details over it. Again, my objective with this section is to give you tools if you are in the need of protecting something on the long run. So those are AI technical tools that will help you in IP management. Then we'll have a brief overview of IP in video games, and I mean more in the creative sectors overall. Of course, like I said, this will be axed thanks to video games, but they will serve more as an example rather than anything. Then we'll cover the protection of AI tech itself. Whether you are a provider or want to be a provider of AI, there are ways to protect your AI tools, anything that you're developing thanks to IP. This is the first section that we'll cover. Then we'll cover the inputs, very, very important section, and the most problematic, I would say, at the moment in terms of case law. The input being both what you feed AI in terms of prompts, but also the data sets that have been feeding AI to deliver the product that you are now using. There is a lot of controversy as to how the information is collected, gathered, and used. We will try to cover it quite broadly as well, but give you an idea of how you could imagine protecting any input you would want to avoid ChatGPT having on the long run. And then the output, that is the most creative aspect, I would say, of law at the moment, and also that stirs a lot of debate. How can you protect via IP rights that have been evolving over centuries, something that is so new and that blurs the lines basically of what creation means? We'll cover some of the issues at the moment. I will try to give as many answers as possible, but at the same time, the problem is that we don't have that many answers from a legal standpoint because the law is often, unfortunately, behind what is happening. So, yeah, use of AI tech as a tool in IP. I will be very brief, like I said. What I wanted to give you is a simple list of tools that you could use on the long run for IP management, thanks to AI, because there's a lot of good things that come out of it, even in the legal sphere. Those are tools that you can go through and that will help you, for instance, choosing the right wording for your patent application, or finding the right niche classification if you want a trademark. So very broad. I won't go further than what I've just explained to you. Feel free to have a look at them after the presentation, or if you ever need to trademark something or to have a patent validated, here are the tools you might expect to need. And of course, even in that field, AI is blurring the lines between what we thought was the norm and what will become the norm because of how fast it is, because of how many trademarks it can submit, basically, trademark applications. So a lot of questions already, even in that field that is less, of course, creative than technical, but still. Apart from this little overview of what you could use to manage it, I really want to delve into what IP is at the moment in the creative sectors. And for that, I will first take the example of video games, like I said. I think it was mentioned in the first presentation as well, video games and the difficulty to frame them from a legal perspective and an IP perspective. The only answer we have at the moment as to what a video game is from the CGEU, which says that a video game is a complex matter, meaning that there are several layers within a video game that could be protected differently. So there's a dual approach between what you can protect through copyright. So for instance, of course, the music, characters, storyline, and the computer program that runs the whole game and the creative aspects, which is differently protected, not directly through copyright, or I mean, it partially can be, like I will explain a bit later on. But so this already highlights the difficulty copyright has in many sectors to reconcile evolving technologies, and a video game, of course, from nowadays is very different from what it was in the 70s. So when the main frameworks, international legal frameworks were adopted, there's a whole world of difference between the two. But what we see today is, one of the information I've given you on a previous slide, is a variety of elements you could individually protect within a game. So it's already another sort of advice, but it's important that you understand this element and that you can protect the game as a whole in a way as well. But the most important element, idea rather, is to be able to separate the components within your company or within your work and understand that some of them require a different protection or could benefit from having a different protection. For instance, trademark applies particularly well to company names, company logos, game titles, game subtitles, whatever, or even a catchphrase. It's of course possible to try and defend it through copyright and saying this is a work of art, this is a work that you've protected, but you are creating a mess rather than just having the formal certainty that you have protected something through a valid trademark. Design rights, of course, and patents are also ways to protect your works, your arts elements within a game. But the element that is often missed or misused in any creative industries, and particularly at a smaller scale, because it's, of course, well used in bigger companies, is trade secrets. Another advice, therefore, is to rely on them as much as possible. You've all had, or at least I hope many of you have had, a good advices and a good overview of what trade secrets should be in creative industries in the previous webinar. Use them wisely, but use them as much as possible and as much as required. They're the best level of protection, and we'll come back to them at the end of the presentation on a list of do's and don'ts within AI. And of course, AI is modifying the creation process of video games. So any creative process is heavily influenced now by AI, and all major studios are using it. Statistics are quite impressive as to how fast this number, the percentage of creators, developers that are using AI has risen, has gone through the roof, basically, and it's now almost all of them that use it. It's the same for other creative sectors. I must thank Jan as well for this piece of information that comes, I think, from a Vlaio study. But it's in any creative sectors, the use of AI is going to increase over time even more, and its capabilities as well. So finding the right balance between your own creation and what is assisted will become even more difficult in the future. But what you have also to mitigate, and what people sometimes forget, I would say, or at least major companies tend to forget, is that the public backlash is also a factor in how you use AI. In the video gaming industry, any use of AI at the moment is disregarded and stirs a lot of debate within the gaming community. There's a winning game I think 2 years ago at the Game of the Year Awards that lost its award because it was using AI as a placeholder for a very minute detail that you see here on the right side of the screen. You can use AI as much as you want in a way, and you can try to use IP to protect it and be as aggressive as you want, or as you want to try at least, in the way you protect it. But you still have to take into account how that could potentially affect the player's experience or the user experience or any viewer's experience, depending on the creative sector you are working in. That said, I think now we've got a good overview of what AI can be. Now we should think about how to protect it, at least how to protect yourself and how to protect the components that you don't want AI, major companies, for instance, to be using. And the first layer is for the ones of you that would want to create AI tools, become providers. How can you protect the technology itself? So say you develop an AI tool that would help journalists write articles faster. What can you do to protect this particular AI tool? Well, copyright law would be the first layer because it's the easiest one you can imagine. However, algorithms within their limits are not protected because they're too abstract. What we protect are expressions, not idea. To give you an example, you cannot blame an artist for using a specific melody if you haven't used it yourself in another song and it was just an idea in your mind. That's the idea expression dichotomy, very grossly explained and briefly explained, but that's the idea. So an algorithm is still considered too abstract to be protected by copyright. And what we see and what we'll cover briefly in this presentation is that copyright law applies to a lot of human-related elements and artworks, and like I said, was created over a long period of time. So it struggled a bit to adapt to the new technological realities of the world. That said, software within itself can be protected, and this can apply to the two layers of software, meaning the source and the object code. However, protecting the programming language is not possible because it would be too abstract again. The good thing about copyright, though, if you want to try to protect anything thanks to copyrights, is that it arises automatically. So you do not need any extra formalities like you would need for patents or trademarks. But again, the protection is at the same time very powerful because it protects the work for the entirety of the life of the author plus 70 years. But it's quite weak at the same time because it's difficult to find its limits, and the limits are usually found thanks to case law, which you usually don't want to get to. What you can still have an easy protection for under traditional copyright law is the GUI and the visual components. Again, that is something very gaming related, but the manuals as well, of course, are literary artworks protected since the Berne Convention. Very broad protection, but the second layer that is more technical that you can imagine, of course, is patent. What you still need to keep in mind when you want to protect something with patents is that the invention has to have a technical character. It's a bit the equivalent in a way of the idea expressed in dichotomy. We require something more. We require an invention that solves a technical problem. And a mathematical method and a computer program as such does not qualify as an invention. It is too abstract. It does not have this technical effect dimension that is required. However, for AI technology, there is the possibility of going beyond the normal physical interaction between the program and the computer on which it is run. And in that case, it can be protected through patents, and all the features that are contributing to that technical new element, the technical character that you can protect, are then considered for this inventive step, which is this sort of threshold that you have to meet. Very technical, of course, but what it means is in practice is, for example, if you were to create an AI tool that has a medical application, for instance, that's an example I think that's given by the EPO. You want to create an AI tool that monitors heart rate and to administer the right medicines depending on the heart rate. The technical effect is there because it's not only the AI tool that monitors the heart rate. It goes further than that. The objective is to administer the medicine at the right time, right moment, whatever. So you've got this extra layer. However, it's a bit mitigated in terms of advantages because you still have strict disclosure conditions for patents. So if you want an invention to be protected, you need to disclose enough elements for it to be reproduced by somebody skilled in the art. Someone skilled in the art, that's the threshold that is used in all patent courts. And that means that for an AI system, it requires you to disclose a lot of information, actually. We don't know how much exactly. Like I said, this is also evolving. But the training data, for instance, is a huge problem. There's a decision that says that basically refused to grant a patent because not enough training data or technical information was disclosed for the invention to be carried out, again, by this person skilled in the art. And at the same time, the EPO guidelines say that, in general, there's no need to disclose those information. So you see this difficulty to find the right middle ground into what you have to disclose to make sure that enough people can do it again and the patent can be granted, and the fact also that it could be detrimental to the protection in the form of trade secrets, for instance, that you would want to keep as to how are you making your AI tool work. Overall, those are two different layers of protection that you can even also, of course, try to combine. Copyright law and patent law, you don't need a separation between the two of them. And those are the way already you can protect an AI tool via IP rights. Here, the difficulties are not that many in terms of making the two frameworks working together. But in the second section here on inputs, it will get a bit messier. So what we mean by input, like I said, is a combination of two things. It's the developer input, so what was used as training data to make the AI tool work, and the user input, whatever you feed it yourself so that you get an answer. And this leads to a lot of problems as well, because the developer input within the official guidelines and regulation and instruments should be limited to public data, meaning scraping of everything you can find on the internet for free and open source, licensed data sets, AI generated and internal data sets, and user generated content, of course. We see, for instance, that the main sources of input and data for the major LLM providers are Reddit and Wikipedia, YouTube, Google. So it can be very broad, and Wikipedia has really saved a lot of AI tools in their early days. However, we also know that the training goes far beyond that, rather unofficially, of course, and this leads to a lot of case law and ongoing case law. Those are the two advices that I can already give you now, meaning to always verify privacy settings. So this is less something related to company or commercial purposes, but rather personal and privacy elements rather than purely IP, I would say. But always verify the privacy settings of all the apps, because whatever you are not opting out from, they will be using legally, which is something we'll cover a bit later regarding the TDM exceptions, so text and data mining exceptions. And yeah, respecting the obligation set out in the DSM directive is the other side of the coin. So if you're a company that wants to scrape data, respect those obligations. There will be a day where some major fines will be paid by companies as a sort of an example as well, because of how important it is from a privacy and an IP perspective it is to respect the TDM regimes that we'll cover in a minute regarding the opt-out. And like I said, it's highly controversial. We know that there has been in many cases the use of unlicensed creative works. So the unlicensed use of creative works has been a major topic of issue for the development of AI tools, because they need it, but at the same time it's a pure infringement of copyright and of IP rights overall. So what you get in answer from that, from the creative sectors, are a lot of statements, a lot of joint letters. There was also an album, a silent album in the UK in 2025 called Is This What We Want, that aimed to raise the voice, basically raise the voice against and raise the alarm against those AI companies that would just create whatever they could find, even if it was unlicensed. And as an author, of course, you wouldn't get a penny out of it. And this reinforced a bit later by a lot of rights holder and companies that protect authors, basically creators, in many different sectors at the EU level, asking for more, basically, control over the AI Act implementation measures. What this leads to more concretely now, rather than just statements, is a lot of lawsuits. And the main issue is that the vast majority of them are in the US and in the US, there will be a lot of settlements. We already have several settlements between Anthropic and different defendants. We will have answers in the coming years as to a lot of questions that will be raised by this presentation. I'm sure of it, or at least I really hope that we will. But at the same time, we know that in many countries, it will just get settled. And because the main country where we've got the majority of the lawsuits is the US, we can hope for the best, hope that we get answers, hope that we know better how to use AI and what the limits of AI companies are. But at the same time, I doubt it a bit. I doubt that we will have the full picture before many, many years. That said, you've got this website that can always help you find links to all those cases, find new ongoing cases. It's called ChatGPT is Eating the World. Very, very interesting name. And it's updated, I think, every day. So you'll definitely have the right information. And there's a few cases that are worth keeping an eye on, namely the Stability versus Getty case that was discussed in the previous webinar and that I will discuss a bit later on. Those are cases that could bring a lot of answers to the questions that will be raised today. Now, in terms of input, from a copyright perspective, there's several elements that go in. Within the copyright framework in EU, there are several things that are used by AI companies, and that could be considered copyright protected. Of course, literary and artistic works, there's a lot of it. Fixations of performances, phonograms, first fixations of films, broadcasts, databases, and softwares, like I said, the source code and the object code. Databases are always problematic. I mean, at least more complex rather than problematic, because they have a sort of double layer of protection. They're protected by copyright because they're considered a work if their structure or the selection of the data they're using is deemed creative because it reflects a certain level, a threshold of originality. But databases, because of their relevance in today's economy, basically, have gotten the privilege of having a second degree of protection, which we call a sui generis right. So what we protect there is the substantial investment in obtaining, verifying, and presenting the content. It does not protect the data in the database, it protects the database itself. All those elements, if you are part of them, working on them or using them, are protected by copyright in some way, shape, or form. So protecting them to the highest level possible is of paramount importance. And the other level of protection you can use, of course, is trade secrets. Like I said, keeping your data as secret as possible, keeping your work as secret as possible for as long as necessary is, of course, extremely important. And even the having a clear framework of how the data you're collecting or using or creating is accessed by different companies that would be interested in it is very important. Terms and conditions, therefore, are important. But what is most important today is the text and data mining regime. This slide is very, very complex, very, very academic from a legal perspective, and it gives you a total and complete overview of what a TDM is. We'll look at it in a very easy way, just with this analogy. This is something Josephine uses and I think is quite striking. You can imagine those light posts as copyright overall. So when you are in a framework where you're benefiting from an exception, so say the research exception or the parody exception, you don't need the authorization, basically, of the author of a work that has been lawfully disclosed and published. You're in the green. You can do whatever you want as long as you keep those limits that are enshrined in the law within those exceptions, basically. But you can do whatever you want with it. You don't need a special layer of authorization of limit. When you're in the red, It means that you have to stop because there's a reproduction that you would be doing if you cross that line, is a reproduction or a communication to the public. So there you are infringing, of course. If you reproduce or communicate to the public a work without any licensing authorization, you are in the red. Those are the two easy ones. And then you've got the orange light. The orange light is the most important element of it is licensing. It's when you get that layer of authorization from the author, you want to communicate a work to the public, you need this licensing model. And the TDM, the text and data mining exception, is the equivalent of that orange exception. You're in a case where if there is no limit set out by the authors, you can do whatever as an AI company, as anybody that wants to scrape information or mine information, you can do whatever you want with it. If there is no opt-out, what we call the opt-out mechanism, and this mechanism has to be complied by all the AI companies since the entry into force of this article of the AI Act. What it means is that all AI companies now have to respect the will of authors that want to protect their work. And how that will is expressed? Well, the opt-out mechanism means that if they don't say anything, you can do whatever you want. But if they say, I don't want you to use my work, you cannot. This is the limit. And so this entered into force since August of last year. All companies that are providing a GPAI, so for instance, of course, ChatGPT is a good example, Claude, etc., they need to have this policy, this copyright policy, to identify and comply with all the regulations on opt-out mechanisms. What this means is that the way opt-out is done is evolving over time. And the technologies behind it are evolving, and you must abide by those rules and evolve if needed with those rules to make sure that the opt-out mechanism is respected. As an author, how is this actually done? Well, there's several ways to do it. So if you want to protect your work from the scraping, the data mining of any company, AI company, well, there are the most easy one, I would say, the easiest one is the stakeholder solution. So the CMO opt-out. What we mean by this is, for instance, you're an artist, you're a musician, you are part of the SABAM, or the SACEM in France. They will have opted out for you. So they've done that a few years back in prevision of what would happen now. Your work that is managed basically by CMOs is opted out by default. This is of course the safest level that you can imagine. But for individual, it's quite difficult. So what you can do in that case is use different formats that are coexisting and evolving. I've linked you a few articles regarding that will give you a broader idea of what you can use to do so. But it's to have those different technical means of blocking AI scraping bots to the best of your abilities, basically, from scraping whatever is online and that you have shared with other people without wanting it to be mined by AI tools. And this includes the most basic one was this robot.txt format. And the problem with that is it's the easiest way to make it efficient, but at the same time, it's the least efficient of the three that you have there. The AI.txt was, I think, privately at the start of its creation was a privately owned company that just wanted to automate this process of protecting your work and make the opt-out a possibility for individuals. So you can use that mechanism as well, and the whole procedure is on their website. Unfortunately, when I just checked before this conference, it was the website was still under maintenance and offline. I hope now it will be fixed. And the TDM reservation protocol is also the same as a similar mechanism that allows the AI companies to find ways to contact you. So legal ways, of course, but to contact you and to try to have a license from you. So it's less it's less of a wall than a door that you can open if you want. That mechanism of opting out is it's controversial. It's highly controversial in the legal doctrine sphere as well. There's a lot of pros and cons. I will not get into too many details about them, but it's worth mentioning. Some authors believe that it was the right solution. At a personal level, I don't really agree with that. The other solution would have been an opt-in, meaning that authors would have had to take those extra steps, those formal steps, to agree to their work being used by AI tools. The arguments in favor are numerous in the opinions of those that defend it. It says basically that it's a valid exception whose scope hasn't been extended too far. It still leaves enough room for negotiation. And if there are good policies in place by those different companies and potentially also equitable remuneration schemes, it could be fair. I mean, in their opinion, it is fair. But of course, this is also met by a lot of resistance in a way from other scholars, of which in a way I would be more part of, because I think that it flips the whole nature of copyright. Like I said, IP hasn't truly adapted to AI yet, and is bound to do so in the next decade, at least I hope. But it flips the whole nature of copyright completely, because copyright is an exclusive right where you protect a human creation, a human element, and you give an incentive with this protection. And there you completely flip it by saying, okay, no, you have to express something, you have to do extra steps just to have that level of protection. And also, of course, this TDM exception was first created for scientific research purposes. And so the AI training, of course, goes far beyond that. And there's hardly any automatic remuneration mechanisms in place at the moment for the scraping of your data. It's also problematic because you cannot revoke your consent. So, for instance, you accept that your work, you accept by not doing anything, you accept that your work is protected, is going to be scraped. There's no way to go back once it's scraped. So yeah, lots of issues from a legal perspective. But there is another way of protecting at least some elements, and that are not copyright, not truly IP either, but that are slightly related, called the personality rights. Personality rights are not a creation of doctrine, but are less harmonized in Europe than copyright, patents, trademarks. What you have, for instance, is in Germany and Switzerland, you've got a general personality right that's protected. What it protects is your value as a human, your nature as a human, meaning, of course, the name, the voice, the face. Those are the most important ones, but you can extend it to numerous elements if you find ways to defend it properly. And this, of course, is relevant to deep fakes. In Belgium, the best protection you've got against that is the right to portrait, which is a protection of up to 20 years after your death of your face, your image on pictures. And this applies, of course, quite evidently to deep fakes. There was a case in Germany already that tried to invoke those personality rights as a protection, a layer of protection against the use of AI that would scrape and use your face, your voice as input. The example is, it was the case of a voice actor, I think, in Germany, and an AI imitation of his voice was done, and without his consent, of course, and without him knowing anything about it. And the case law was a bit disappointing in a way, because it didn't go as far as completely prohibiting any use of your voice through the protection of personality rights. However, it confirmed that the AI's voice cloning with more common a violation can be seen as a violation of your personality rights. What it leads to usually is a compensation, so an economic compensation. But another very recent case was in Belgium, actually, and it was also an actor in Flanders. There's the article under the compensation word. A Flemish actor that was surprised by hearing his voice on a commercial that he didn't voice. So this also led to compensation. I don't know if he's gonna seek compensation in front of a court, but at least this gives you another opportunity to protect those elements that are near and dear to your own soul, in a way, to your own personality. In the creative sector, how can you apply this? Well, if you are just even having your face on your website, this is also something that could be scraped if you don't have an opt-out in place, and if you don't have strong personality rights as a backup. This could just easily be used in a video game, and you could see your face through AI use being reproduced in a game. This is very extreme, of course, but this is the true reality of what it is. Now that we've seen inputs both from the prompt element and the opt-out mechanism, of course, and what feeds AI beasts, it's time to have a brief look at outputs. So this is where we've got a lot of debate, because theories are emerging as to what we should do with this IP framework that doesn't really follow the AI trends so well, or at least is slow to do so. Should we grant copyright protection to AI systems, or at least AI driven creation? Or should we create a sui generis right that would protect the investment the same way we have for databases? In terms of patent law, should we have a protection of AI as inventors? Those are all questions that we'll talk about briefly now in three categories. First, we'll look at authorship and inventorship, which is something I just mentioned. Then ownership, very important. It's important to make the distinction between the original author, the original creator, and who owns the final product. And what ways there are at the moment in terms of infringement procedures. How can you contest? How can you claim that a work was yours or was stolen, for instance, by AI? So the first layer is IP. Like I said, easiest one to get, but intrinsically links to your human nature. We see this element everywhere within texts, and whether it be at the national level or an international level, the author is also the first owner. The term of protection is beyond the life of the author, so even that threshold is created around the human life as we know it. Moral rights are intrinsically human as well, and equitable remuneration as consideration for certain exception, of course, is also based on a very human approach to, well, feeding yourself, having some money out of your work, and an AI tool has less of that kind of incentive, of course. And the latest example we can give of how humanly centric copyright is the Naruto selfie saga. I should have picked a picture of it, but it's the famous picture of a monkey that took a selfie, and it was argued by PETA in the US that he had the copyright over the picture, which of course made a lot of money to the photograph. And at the same time, it was a good plea from them to argue that animals have rights, basically. I mean, it was denied, but the idea also reinforces the human nature of copyrights. And this is the same position that is used in the US as well at the moment. So copyright only protects material that is the product of human creativity. The term author, which is used in both the Constitution, excludes non-humans. It's ubiquitous, of course, but of course it gets difficult then to find the limit between computer-assisted creation and pure human creation. The difficulty also arises because the threshold in copyright is quite low to have a creation. And the Pioneer case, for instance, is a very good example of that. This was about a picture, the one you see on the right, and it was argued by the defendant basically that this wasn't a true work because there was no creativity, there was no free and creative choices. And the court decided that yes, indeed there was, in the choice of background, pose, lighting, framing, angle of view. This leads then to the same thought process for AI. If you have a prompt, is it enough to say that you have made free and creative choices, or is the result purely AI generated? Then if you make changes to the image, if you make changes to the script or to whatever the output from the AI tool is, how far does it need to go from the original AI created element to be copyright protected? Open question, no clear case law. Unfortunately, this is something I don't really have an answer for, and there is no material threshold that we have at the moment. It's going to be on a case-by-case basis for the foreseeable future, and we can hope for the best. We can hope for an evolution. What it will remain for a long time, at least, is a specter of colors like we use it here. We'll come back to that as well in the patent section in a minute. But you have those extremes of the purely AI created and the purely human created, and the middle ground is where all the problem lies. If I had to give an advice based on what I just told you for creative industries, it's to rely as much as possible on purely human creation, of course, but I used AI tools as well. The layer of AI creation should never replace the human element. So at least from an IP protection perspective, a copyright protection perspective, you cannot, both morally and economically in a way, block other people from using something that you would have completely made with AI tools. It goes against the nature of copyright in a way. However, like I said, we don't have a clear case law. Maybe the courts will prove me wrong in the coming years. At the moment, this is what we have. And the same goes for patents. Patents are inherently linked to the human nature. It's implied in many cases rather than purely stated as a human creation. However, you have those references to the inventor as the first owner, and the same rationale basically applies everywhere. There was a creator in the US, an inventor in the US, that a bit as a challenge of the law tried to have an AI tool recognized by the patent courts as the original creator, the original inventor of the invention. And it was refused by the EPO. It was refused in both the first instance and in appeal. We reject at the moment any AI-created inventions. That said, we know that AI is used in the invention process. Same thing as for copyright, it's a specter. If you completely invent something new, and if it is, for instance, in the video game sector, if you invent a completely brand new engine, gameplay mechanics, whatever it is, you are for sure in a situation where you can get a patent. But if you are completely relying on computer-generated inventions, you are in the zone of unpatentability, as we could call it. And the middle ground is the same debate. It's the same case law basis at the moment. So how now do you assess this in practice? Both as courts and as users, this creates, of course, a lot of debate. This is the center of the problem. We have AI that gets so good at mimicking human creativity that it leads to the existence of what we call copy fraud, where you abuse of that presumption of authorship. And the example you see on the right was a photographer that admitted later that the picture he received prizes for was completely AI generated. And what is quite crazy is that we now have the opposite. As well. We've got pictures that were taken by a human and that get denied access to photograph competitions because they think it was AI generated. So perfect example of how difficult it is to assess it in practice. The famous AI Act tries to give some layers of answers, and we will see that become applicable very soon. So in August of this year, Article 50 regarding the transparency obligations will come into force. And what it means is that all GPAI providers, so whether it be ChatGPT, Claude, Euria, whatever, will have to have a sort of machine-readable watermarking of all their synthetic content. What it means into practice is quite difficult still to assess. We have yet to see the exact nature of that machine-readable format watermark, but what we know is that it will technically be prohibited to not be able to see within this machine-readable format that content was AI produced, whether it be image, video, text, whatever. And it goes a bit further as well for a more serious topic in a way, for deepfakes. So because of their dangerousness, the potential of destruction that it could have on anybody's reputation as well, the obligation is now not on the provider of the AI. So, for instance, the provider would be Anthropic, and the deployer would be anybody using it for its business. The obligation of having this generation, this little watermark, is a bit stronger there, because for deepfakes you will have this extra requirement of disclosing it when it has been artificially generated or manipulated. So any content, again, the way it will be expressed is still unclear, but what is most likely to happen is that on any content that is AI generated and that consists of a deepfake, you should have a marking at the end or throughout the whole video, for instance, that says AI generated. The goal is, of course, to avoid any harmful deepfakes that can be done. We have yet to see how it's going to work. What we already have is what we call the AI Pact. So many companies and major players have taken a voluntary pledge to, make the best efforts to respect those initiatives and those legal requirements and to label AI-generated content. But there's a lot of questions as to how it's actually going to pan out and how it's going to be used. Unfortunately, those are questions that I cannot afford to answer now because of how complex they are and of how little information we have from the courts. But we will see evolutions in the legal sphere. And the advice that I can give you that comes out of it is keep in touch with the law in general in your sector, because it will get affected at some point by courts or by case law, of course, or by legislation or even just guidelines. What we see at the moment is there is no legal personality, there is no inventorship, like I said, also for AI tools. Is it about to change? We don't know. I guess not, but we don't know. Do we consider that they create something? Like I said, technically they don't. And a clear example of that was given by the MIT in a study they made with comedians, and which basically came to the conclusion that AI was not able to make funny jokes because of how because of how jokes rely on mechanisms that are beyond the comprehension of those AI tools. So there's a lot of risks, of course, related to the evolution of the legal framework. What we still can hope for is a lot of artistic freedom left, even with a lot of AI tools that could help him, and their help is going to get better and better. One of them is Cara. You can check it out online as well. It's an AI tool that was created for artists overall. And the second problem, apart from the law that will have to evolve, is that we still have no answers as to who owns what. So do we say that AI itself, the tool, Claude, owns whatever it creates, the output it creates? It would go again against all of the true nature of IP. Maybe in the future, maybe we will have a new regime that will emerge over the years. Should we say that it's the creator, so the programmer or the designer? Well, I mean, they already own the AI tool, so it would be quite abusive in a way for the true artists or authors that are trying to have the help of AI to credit them as the owner of the work. Many categories, so the trainer, the user, the investor, maybe a form of co-ownership, a sort of a co-production like you saw in the previous conference, is possible, but we don't have the exact answer. My personal opinion would be to have it as public as possible. This is also something that we aim for with our platform within the iGame project. We believe that the best way forward with that kind of tech is that the result, at least, maybe not the tech in itself, but the result at least is public and usable by everyone without any additional burdens. And within your creative sectors, I would argue that this is the safest way forward, at least, both in terms of potential public backlash and of potential legal consequences. What we see already, like I said, is a lot of case law. We will talk about it in a minute. They will definitely bring answers to exactly those questions. And the infringement part is probably the most complex one at the moment. I was also, in a way, asked to have a quick overview of the intermediary liability regimes that apply in that sector. I will be, again, very brief because I see that it's been already 55 minutes and I still want to have some time for the do's and don'ts. Basically, the regime is relatively complex, but when you're a platform that hosts content, what are the criteria to have you liable for the infringements that would be made by its users? So say a user infringes on copyright and places a video on your website. When are you liable? Well, the regime is provided for by the DSA and the DSM. The DSA protects largely companies, intermediary companies, through three mechanisms. So platforms that are hosts that are just doing caching and mere conduit, what we call mere conduit activities, are protected in a way. There is a safe harbor for them. They cannot be held liable for the infringement of somebody else. However, they have a lot of transparency obligations, and they need to have what we call notice and action mechanisms in place, meaning that you need a specific document or framework in place for when users find something they deem copyright or IP infringing. And this goes even further for VLOPs, so very large online platforms. This means having risk assessments and mechanisms in place. I wish you, for all your companies, the best in terms of growth. If you get to that threshold, the requirements go a bit further, of course, because of the budget you can allocate to that those tasks. The DSM goes a bit further even for the online content sharing platforms. So the perfect example, of course, is YouTube. It can also be held liable for copyright infringement. So it kind of reverses the safe harbor mechanism. But they can be held liable for copyright infringement unless they have made what we call the best efforts to prevent the infringements. And this means that they've tried to get an authorization for the content. They've made subsequently, their best efforts to block the infringing content. And if they have that notice and take down mechanism in place and have a notice of an infringement, they have acted quickly upon notice. If you don't, you can be held liable for the same infringements as the one done by the user. Right, back to AI in a way. Well, case law will bring answer, like I said. One of the case to look for is this one. You've got the number on the page here, and you can just search for like company. It will give a lot of answers as to what a reproduction is in terms of AI training. And it was basically a chatbot, an LLM chatbot that was reproducing or not, arguably, content from other websites by predicting the next words. And the prediction was, of course, exactly the same wordings as the titles of articles, for instance. So the questions relate to the TDM as well, the TDM exception as well. What can we consider TDM in that scenario in terms of training and in terms of observation of patterns? Those answers will come from that case. What we already have now is a trademark and copyright law case between Getty and Stability. It was mentioned already in the previous conference. It's a very interesting one where we basically Getty realized that Stability had mined everything from them, and they had a perfect proof because the watermark of Getty was on many AI created pictures. So three things basically were argued by Getty. It's that the training on the image was a copyright infringement, the distribution of the model in the UK was also an infringement, and the watermarks was a trademark infringement. The relatively sad thing, in a way, is that the UK court didn't take a lot of risks in answering this, and basically only argued that and recognized that there was a trademark infringement. The two other claims were dismissed and abandoned because they weren't UK based. What we have now is the exact same case in the US, still ongoing between Getty and Stability, and we can hope for the best. We can hope for more information from that case, and if it doesn't get settled, which could, in my opinion, would be a miracle, we will definitely have an answer as to what training is in relation to copyright infringement. In regards to trademarks, Josephine is an expert in trademarks, so she knows best about those questions, but many, many questions arise as well. We've seen the patents issues, we've seen the copyright issues. In trademarks, there are many. Unfortunately, I see that I'm already over time, so I will not go into details for all of them, but basically the strength of AI tools puts every mechanisms of IP into question again. So on that note, what can you do? Well, in any creative industry, apart from the few advices that I've already given you, the most important one would be to have a background check to avoid any surprises. What I mean by that is when you create something, when you have a brilliant idea, make sure nobody before had the same brilliant $1 million idea. So it includes trademark search, copyright protected inspirations, patent search, and AI can help you with that with the tools that I mentioned at the beginning. And the second layer of protection is to protect as early, as broadly as possible in all key markets. What I mean by that as well is that the extra 700 or 800 euros you would have to spend to protect a trademark further than the original scope in provision of potentially going abroad with your business is of paramount importance. You could regret it on the long term, particularly also because there are in a way, trademark imposters that specialize in finding trademarks that are needed for a company and that are not yet used in a certain territory. So what they do is to trade it first, to trademark it first, and then it's up to you to find a way through it. So trademark as broad as possible. Have patents if you have a $1 million invention, have patents submitted as early as possible. And in any other scenario, rely as much as possible on trade secrets. They can be very broad. It concerns all level of information within your company, with your employees. And it's also through that kind of document that you need to pay attention to what employees or yourself would use as input on AI platforms. So having a clear AI policy is very important. I'll come to it in a minute, but the first layer is always to know what you are typing in any AI tool. LLM, for instance, if you're asking Claude a question, the inputs you're giving from a trade secret perspective will destroy the trade secret if you feed it to Claude. it's of course very difficult to prove, and it would require a super high level of transparency from cloud, but this is a true possibility within the mechanisms of trade secrets. So pay attention to what you write, pay attention to your privacy in what you write, and use it as efficiently, as effectively as possible without giving it too much information, because what you give it will feed it over time. And if you are creating AI tech, please respect those mechanisms that I mentioned regarding AI transparency. It's of paramount importance. And if you're using AI as a tool, be transparent with your audience as well, that AI helps, because if it gets public in any way that is not that is out of your control, in a way, it could backlash. I'm not making this up in a way, but the video game sectors has proved it over time. The controversies surrounding AI use in video games keep on happening, mostly because, I guess, of poor communication and marketing in a way from the game studios. And under the second level, basically, of protection that you need is a clear foreground plan answering the question who owns what in the future. Like I said, it's very difficult to frame ownership of AI-related content at the moment, but this goes back to one of the advices I've given earlier on. If you have a sufficient level of human input, you can have a protection. And it's important that within your company, all layers of workforce know if they own something, or if the company owns something, or if you as the boss, whatever, own something, or even as a creator, do you own something against, in a way, your boss, for instance. And this goes back to AI and IP policy and clear terms and conditions. What I mean by that is that it's very hard to reconcile at the moment the end user license agreements, terms and conditions, AI and IP. So those are four frameworks that have to find a way to work together, which really don't, at the moment at least, not perfectly at least. And it's important that within your company or within any work-related practice you have going on, the IP aspect, the IP management of what comes out or what goes in any AI tool is managed as efficiently as possible. Related again, but the national IP employment regulations are very important in answering the who owns what question. You've got opposing doctrines depending on the countries in which you are from, regarding if, for instance, your employer is considered the author straight away of anything you create in a work-related environment, or if, as a creator, even if you're an employee, you first own what you create and then have a form of implied transfer scheme going on, license transfer scheme. And the level of regulatory change that you should monitor is very broad. It's both national, regional, and supranational, meaning both EU level and international. Like I said, case law will influence that greatly in the coming years. Whether the US decisions would truly influence what we do in Europe is unsure because of how different the IP world is in the US and how it is here in Europe and in Belgium. But in any case, it's very important to monitor this within your company. It's often forgotten in a way. The IP management is a complex task that rely often on contractual practices rather than the relying on the regulatory framework, but it is very important for your company to do so. So I hope that with all those advices and all those, in a way, I'm sorry, unanswered questions, you've got a better idea of what IP and AI are and how they work together. I thank you for your attention. I'm sorry I went a bit over time, but I thought it was very important to go over those do's and don'ts in detail.